Yeah, just a second, sir. I'll read the rights and then I'll give you a chance to speak back with her. All right, everyone, thank you for your patience. A few important matters before we begin. I always want to make sure you understand what your rights are. Even if you've been here before, it's important that you know what your rights are. Your first right is to remain silent. That means when I call your name, though, you do have to come to that microphone and your hands must be visible. You don't have to make a statement. If you elect to remain silent and we have not entered a plea, I will enter a plea of not guilty for you, which will move this to the next phase or the next hearing. That hearing is likely a pre-trial, but you also have a right to a trial. The trials are before me, which are called bench trials, unless you make a request in writing for a jury trial. Before either one of those, we will make sure that you know the evidence against you. At the trial, you can cross-examine any witness that the city calls, and you can have your own witnesses appear. And if your witnesses won't come based on you asking them, we will subpoena your witnesses for you. In addition to the right to remain silent and the right to a trial, you have a right to an attorney, which is why there's always a delay before I come back out in the morning, because we want to make sure that everyone who needs to speak with the defense attorney has had that opportunity. If you have not, we will give you a chance to speak with her. Or if you would like to hire your own attorney, let me know and I'll give you a chance to come back with your own attorney. When I call your name, there are 4 types of pleas that you can enter in a court. Not guilty resets this for another hearing or a trial. Guilty is where you are admitting what you're accused of. And if you do that, I could sentence you today. A sentence in a municipal court ranges from $0 to $1,000, 0 days in jail up to 6 months in jail. That's the jurisdiction of this court. Anything above that is a felony, and I'll address those shortly. That's on a guilty plea. There's also a plea of no contest that can have the same result. The difference is a no contest plea, you're not stating with your own words that you're guilty, but you are not contesting the allegations against you. That means if you are found guilty, the plea cannot be used against you in a later proceeding. And then there's a plea of not guilty by reason of insanity. If you choose that particular plea, I would have to stop these proceedings to see where you are and your ability to go forward. But keep in mind that plea is not available for your traffic cases. The presumption is that if you're driving, you do have the mental capacity to do so. All right, speaking of your traffic cases, if you're going to resolve a traffic case and if you get points, the BMV will be notified of your points. If you accumulate 12 or more points on your license will be suspended. And in Ohio, driving under a 12-point suspension could have you subject to jail time. So make sure you know where you are in regard to your points. Also, you must have insurance to drive. That means if your ticket is marked no for insurance, when the BMV gets a copy of it, they will suspend your license. What I normally do is give you up to 72 hours to get insurance, come back to the clerk's office, we'll update your file. Just so you know, I also give you 72 hours to take care of your fines and costs. And what that means is if you cannot handle it today, within 72 hours, come back up, request a payment plan, and we will make sure that you're able to take care of your fines and costs through a payment over time. Other thing I want to mention is if you're here for driving under suspension, that has gotten very expensive in this county. The fines range between $500 to $1,000, 2 points on your license gets suspended, and some judges give jail time. What I do in this court is I give you a chance to come back with your license. If you do that, I'll start at the minimum fine of $500 and I'll go backwards, taking off money based on the fact that you've gotten your license together. I won't give you any points. I don't suspend your license and I don't give you jail time. So the bottom line is do what you can to get your license valid. Last thing I want to mention is if you're here for a felony, do we have any felonies this morning? You still have the right to an attorney. You have the right to know the charges against you, and you have a right to what's called a probable cause hearing. That's a hearing where the city has to put on some evidence that a felony was committed in the city and why they believe you are connected. Not that you're guilty. But if they can make that connection, basically what they're saying is that this is a case that is bigger than this particular court, and I have to send it to the county. The other way for it to get to the county is for you to say, Judge, I understand what they're saying. I'm still maintaining not guilty. Go ahead and send my case to the county. Either way, your court date will be Monday. 12th floor of the Justice Center at 9:45, and I will set a bond so that you can try your best to get out of here. If you don't get out on the bond, you will be transferred to the county. All right. I'm going to continue to let you speak with the defense attorney if you need that, and I'll call the cases. Thank you. So I'm going to call most of the cases that I think we can get resolved even with the prosecutor not present. Rashawn Rowe. This is 16 TRD 03171, an old driving under suspension, speeding, and reckless operation. They also have seatbelt. You have shown your insurance, and the city has agreed to have you only plead to 2 charges, the seatbelt and an amended charge that keeps you from getting this driving under suspension on your record and your lower fines. It's called failing to display. How do you plead to that charge? Is it guilty, you said? All right, as opposed to $500, I'm gonna cut it in half. It'll be $250 plus cost. The seatbelt, it looks like you're gonna plead to that. That's a $30 fine. How did you plead to that? All right, and then the other 2, which would have carried points, again, you're not getting any points here, they will be dismissed. Reckless operation is dismissed, and it looks like there was a separate charge of speeding that's dismissed. So you go to the clerk's office, and this is for everyone. If you posted a bond, they'll do the calculations there. If you owe us any money, I can give you time to pay. If you owe us, yeah, I'll give you time to pay. But if we owe you, you get that money back. All right? Just go to the clerk's office. Take care, sir. Mark Dowdell, 20 TRD 03712, driving under suspension and disobeying a traffic device, November 2nd of 2020. They are, it looks like you're just pleading to the driving under suspension, correct? Yeah. So your license aren't together yet?
Yeah, I took it everything. They still gave me an extra suspension.
All right. What was that administration of suspension based on? Was it an OVI or something like that?
I think it's driving suspension.
All right. So did they tell you when you're going to be able to get your license back?
They said it this year.
All right. So let me do this. I'm going to give you the benefit of the doubt. I'm not going to amend it all the way down to failure to display because you don't have a license, but I'll amend it to no driver's license. That keeps you from getting points. And when you go to get your license reinstated, your fees at the BMB are less because of this amendment. All right. All right. So yeah, but what happens is because you got this new charge, there will be new fees once you get your license. But I'm going to make sure it's even lower than what it would normally be. So as opposed to you pleading to driving under suspension, a lesser charge is no driver's license. How do you plead to that? All right. And what I'll do, it's normally a $500 fine. I'm going to reduce it to $300 plus cost, dismiss the other charge. And again, your bond will be applied. And we'll go from there. Okay. Take care, sir. Sonia Wood. Miss Wood is 21 TRD 01056, improper turn in the intersection on February 22nd of this year. And then there's a seatbelt charge as a passenger. That's going to be dismissed. And it looks like the moving violation is amended so that you don't get any points. Is that your understanding? That's called unsafe motor vehicle. Keeps you from getting any points. How do you plead to that charge? Okay, so you want to maintain not guilty and take it to trial? Okay, so let's set a trial date. Ms. Wood, I'm not sure why you signed a plea agreement. You don't want to do that if you don't want to enter a plea.
I don't understand what.
Okay, so let me make it clear. Let me back up there. What they are saying is that on February 22nd, that you made an improper turn at an intersection. They're saying that you were in a 2010 Mercury,
Yes.
Euclid Avenue, Anila. They're saying that there was an accident, and they're saying that you made an improper turn. So if you want to maintain not guilty, which you can, that means the prosecutor, through the evidence from the police, they have to somehow prove that you did this. You don't have to enter a plea to the charge that the city had offered. You can maintain not guilty, and they would have to prove it in a trial. Is that what you'd rather do?
Yeah.
Okay. Let me set a trial date for you. April 5th at 1:30 will be the trial date. We'll give you a reminder so you don't forget that date, okay?
Is it downtown?
No, you'll be right back here in East Cleveland, yes. Right back in this courtroom on April 5th. And if you have any witnesses that you'd like to bring, you can bring them on that date. All right.
Okay, what do I do with this?
That's just your reminder so that you know when. So yeah,
Okay,
yeah, keep it with you, and I'll see you back on April 5th.
okay, thank you.
All right. Keep it together. Ricardo Sanders. Mr. Sanders, 16 CRB 00288. March 7th, 2016, alleging disorderly conduct and criminal damaging. And it looks like you were prepared to enter a plea to the disorderly conduct. Is that how you want to resolve the case today?
Yes.
All right. So how do you plead to disorderly conduct?
He's guilty of disorderly
I'm going to dismiss the other charge. Tell me what happened.
conduct. I had, well, at the time it was the iPhone 6 Plus that came out. I had said that I had a little store counter. That's a little store counter I had of my best friend brother. He do a lot of drugs and stuff like that though. So his autistic son was with me. So I had to pay attention to him because he's deaf and plus he's autistic.
Okay.
So I had to pay attention to him. So as I paid attention to him, I left my phone at the counter. I turned around and attended him, and he ran the store. So I ran the store. I grabbed him. I went back in the store, and the guy told me that the guy said that I didn't leave no phone there. I said I did. I just left my phone right here. I had to grab the little boy. I said somebody in this line took my phone. Can you just hold the door or rewind the camera or something, or call the police or something so I get my phone back?
Okay.
Do it. They told me he got the stuff. So then the guy was like, I said, no, I think this person right here stole my phone. So he wouldn't do nothing about it. And then I left out the store and I shut the door on my way coming out the door. I had the artistic boy with me. So I shut the door coming out and he said I slammed it too hard. Well, I don't know.
You might have, he's probably upset.
I was upset.
Right.
And I shut the door and the glass broke.
Okay.
And he made it seem like I just went to the door and punched the glass
okay.
out, and I didn't do that.
All right.
So
did
I
you
stay there till the police came, and then the police came.
Okay, so that's what happened. All right. Oh, that's not name. Did you hear about that situation that happened in DC? Like the last couple of months? It was a cell phone situation. There was an African American at a hotel, and a Caucasian woman walked up to the man and his son.
I did see that.
And was saying that he took the phone and it got all out of control. So those phones, folks get upset about the phones. I see that. So what I'll do in your particular situation, it was a while ago. I'll accept your no contest plea. It'll be a $100 fine plus cost. The other one is dismissed. All right. So you just go to the clerk's window. They'll do the details there.
Okay.
Take care, sir.
All right, thank you.
Nothing you can do about it. No original complaint. The prosecutor didn't present it, and she signed off on the plea. You know what I'm saying? Like we can't. It's not even proper for us to do that job. You know what I'm saying? That's sad. Yeah. I don't know. I don't know what she be thinking. Well, you gotta do your work all the way through. I don't know. Tyreek Mills. Mr. Mills, this is 21 TRC 00786. This was a driving under the influence from February 12th. No headlights, reckless operation, red light, and the seatbelt. Madam Prosecutor, how are we proceeding today?
Yes, Your Honor. And I twisted events. I listened to this young man. He's 23 years old. He has no prior OVIs on his record. The way things kind of happened that night, he refused the breathalyzer, and the police didn't think it was a good idea for him to perform the field sobriety. However, he showed me some evidence that he's in school for HVAC, and I know that things like this look pretty miserable on your record. The officer that wrote him the citation is currently out with a broken foot.
Okay.
So I'm not quite sure when he will return. I tried to retrieve body cam footage, and it doesn't appear that it was operational at the time. So I'm going to give him a break this time since this is his first, and I'll allow him to plead to the reckless operation in the future.
All right. So, Mr. Mills, is that how you want to handle it? A no contest plea to reckless operation?
Yes, sir.
All right. So let me hear from you. How do you plead?
No contest.
All right. So I'm just going to say this real quick. What the prosecutor is doing in this particular case by dismissing the OVI is giving you a huge break. I try to explain to people all the time that an OVI will change your life,
right,
even if it's just for the short period. I mean, you get it on your record. You're on probation for 6 months to a year. You have to go to AA classes. You may have to have treatment. You have fines and costs. I mean, it's a lot that goes on from driving drunk, and people don't realize that. And the city is giving you a huge break by not even dismissing that charge. So make sure you be responsible, take care of your business. If you're going to drink at home or have somebody drive for you or get an Uber or a Lyft, you know what I'm saying? But don't put yourself at risk. All right, so what I'm going to do, operation in a willful wanton manner, your no contest plea, it'll be a $300 fine plus cost, but everything else other than the seatbelt, it looks like is dismissed, all right? So you have a bond. It looks like some money should be coming back to you, and just be careful going forward. So you're missing everything. No probation, none of that. So it's a good break for you. Make good decisions, okay? Take care, sir. Just go to the clerk's window. Robert Johnson, 21 CRB 00114 is domestic violence from January 30th, and we had already maintained not guilty on this. I gave you a personal bond. There's been no contact, correct? And you're maintaining not guilty. So what we're going to do now is actually set it for a trial so that the city, at this point, they have to prove these allegations. And it's going to be set for May 13th at 1:30. Any questions about that? All right, Mr. Johnson, we'll see you back on that date.
Thanks.
All right, keep that no contact, all right?
Sure.
All right.
All right.
Was that 1:30?
Yes, 1:30. You brought up all the jails, right? Cool. Kent McLaughlin. All right, sir. Let me see how we're handling your cases. We have a few of them. So let me start with one that I see is being dismissed. 20 CRB 00404 from May 7th, 2020, open container littering and intoxication. It looks like that entire file is being dismissed because you resolved some other ones, correct?
Yeah.
All right. And that also goes for 19 CRB 00436. That is being dismissed also. And then that leaves us with two files being resolved, both from 2019. 19 CRB 00435 is from March 7th, and it's an open container charge. Open container is a first-degree misdemeanor, which means you could get up to a $1,000 fine and 6 months in jail. Then we have 19 CRB 00619 from May 13th, which was disorderly conduct and intoxication, which is going to be reduced to a minor misdemeanor that carries no jail time, but a maximum fine of $150. Is that how you want to resolve those cases? How do you plead to the open container
No problem.
and to the disorderly conduct? All right. Mr. McLaughlin, do you, and I just mean this in all sincerity, do you need any assistance with alcohol or anything like that? Because these cases have a similar theme, and maybe that's something you need some help with, because we do have resources through the court.
I'm already there, John. I've been sober since 7/13/2020. I'm currently in the aftercare program. I have certificates.
Okay.
Of completion. And certificates of completion of our plea. And what had happened, I relapsed. So I go to China. Maybe it's true, maybe it's not. I'm alcoholic.
All right.
But I'm in recovery and now I'm sober. And God's good and life is better.
Absolutely, my brother. All right, what I'm gonna do then, let me see what I will do. Let me see that. So what I'm gonna do in 19 CRB 00435, accepting your plea of guilty, there'll be a zero fine, zero cost on that one, right? So I'm gonna give you a reward for the work you've been doing. And then on the last one, the disorderly conduct, as opposed to a $150 fine, it'll be $75 plus cost. And if you need time to pay that, we can work with you, okay? So basically you got 5 cases resolved and you only owe $75 plus cost.
Okay.
So,
I do community services.
well, what you can do is once you find out how much you owe, at some point you can speak to the gentleman behind you, because we didn't have community service during COVID, but now that things are getting a little bit better, we may open that back up and he can get your information so we can provide it for you, okay? Take care, sir.
Thank you.
Stay on the right track. Good job. Kiana Collins. Ms. Collins, 20 CRB 00765 is an assault charge. And Madam Prosecutor, how are we pleading or resolving it today?
I had some discussions with Ms. Ivory concerning Ms. Collins. She's currently in drug court downtown on some prior issues. What we wanted to do was let her plead to the assault, but as opposed to sending it down with the other cases, we want to just mark it like her to submit it here and hold the sentence in abeyance, give her an opportunity to complete drug court, so that at least if something goes wrong with drug court, she still has 6 months hanging over her head here. Because this could have been a potentially serious situation. It starts off in a store and she's arguing with this lady over not wanting to give her her food, and he punched her in the face and bit her, and the lady was pregnant at the time. So we don't want to demean the seriousness of the offense, but give Ms. Collins a break for the fact that she does appear to be in way better shape than she's been in a while. And my understanding is she's been compliant with drug court downtown.
All right, and Madam Prosecutor, I'll go ahead and rely on you to give us that date when she is nearing completion with drug court, and we'll bring both cases back up.
Yes, Your Honor, she's moved to phase 2 now, and she is in compliance.
All right. So, Ms. Collins, you understand what's happening now? So what I understand is that you're going to admit through a plea to this assault, but we're going to hold everything off to let you continue the work you're doing with drug court. Is that your understanding?
Yes.
How do you plead?
Guilty, right?
All right. Yes.
No contest?
No
Okay.
contest is fine.
Okay.
And based on the information provided by the city, there will be a finding of guilt, but I'm going to hold everything off, continue working with probation, continue with drug court, and we'll get this all resolved together once we're done with the other case, okay?
Okay.
All right. Thank you.
When do I ever come back?
So what you do is you keep your drug court appointments, right? You know those?
Yeah.
Miss Ivory is always made aware of when you're completed. So she goes to your graduation, and then she's going to let you know when you come back to me.
That's going to get explained.
I'm sorry?
If they tell me it was going to get explained.
Yep, the drug court case, yep, it will be. And then we'll deal with this other one.
Okay, thank
All right, you take care. Lamont,
Or at least you're dismissed.
yeah, Lamont Parson. Is Mr. Parson available?
Yes, I'm here, sir.
All right, come on up. Mr. Parson, I have two cases, a traffic case in 21 TRD 01276, alleging that you didn't change your signal, or you didn't use your signal when you changed lanes on March 6th. And I believe that's connected to a March 6th weapons under disability, trafficking in drugs, and drug possession that are felony charges. You understand that? All of this allegedly took place. Let me read the complaint for you. The drug trafficking, which is a felony of the 4th degree, 6 to 18 months is a possibility and a $5,000 fine, took place allegedly on or about March 6th, saying that while you were a driver, while in the driver's seat, you were found to have 2 Red Bull containers containing 6 bundles of crack cocaine in the driver door next to you in the city of East Cleveland. And then there's possession of criminal tools, a felony of the 5th degree, 6 to 12 months and a $2,500 fine, alleging that you did have a .22 caliber firearm, multiple clear bags of cocaine, as well as the currency of $624. And then there's having a weapon while under disability, a felony of the 3rd degree, 9 to 36 months and a $10,000 fine, because what they're saying is that while you were found to be in possession of the firearm, you had already had a previous conviction of a felony, which keeps you from having a weapon. So you understand where all the charges are? Well, here's the deal. You're going to maintain not guilty through your attorney. So, but what my responsibility today is that these are charges that are bigger than the municipal court. So we have to get them down to the county one way or the other. You understand that?
Okay.
Through your conversation with Ms. Conwell, the defense attorney, Ms. Conwell, how are we proceeding in regards to the preliminary hearing?
With regards to preliminary hearing, I've explained this person's rights. He's chosen to waive those rights and proceed.
And are we sending the traffic case along with the felony?
Yeah, because they all have the same date, even though I don't have police report, but I suspect that they're probably all related. So
Okay.
I would think so. I see the detective nodding his head something.
Yes. And Detective, what's the issue of the bond that you're suggesting?
Yeah, we had the bond set for $60,000.
All right.
He does have three convictions. He does have a trafficking case and a couple other convictions.
All right. Mr. Parson, are you able to pay that, post a $60,000 bond?
No, I'm not. Nowhere near it.
Do you know what type of bond you can post?
Probably a $2,000 bond.
All right. Detective, would there be an objection to a 20,000?
Yeah, 20,000 fine.
All right. So I'm going to reduce this to 20,000, 10% cash or surety, which will give you the ability to pay about 2,000 to get out.
Okay.
So if you are able to pay that within the short period of time that you're here, do it so that you can walk out of East Cleveland. If not, you'll be sent to the county. You can pay the bond there, but that judge has the ability to raise the bond if they felt necessary, but they may even lower it. But I did reduce it to what you can afford, okay? Your court date will be Monday, 12th floor of the Justice Center at 9:45.
All right.
All right, take
You
care.
have that in my paperwork?
Yep, we'll give you a reminder. Absolutely. Deshaun Wright. Is it LaShawn? I'm sorry. Thank you, Miss Wright. All right, Miss Wright. March 6th, alleging no driver's license, driving under the influence, impeding the flow of traffic, as well as a separate charge in 21 CRB 00244 of consumption of alcohol in a motor vehicle. All right. And it looks like Madam Prosecutor, she's entering a plea of no contest to the OVI, correct?
Correct.
As well as impeding the flow of traffic and the no driver's license, correct? And you're dismissing the second charge?
Yes.
So, Ms. Wright, you understand that driving under the influence requires mandatory jail time. If it's your first time, you're looking at a minimum of 3 days in jail. It could be as much as 6 months. I could suspend your license, or at least I have to suspend your license. The minimum term is a year suspension. It could be as much as 3 years. If this is not your first time, you're looking at more jail time. You could be looking at 10 days mandatory. And there's a possibility of house arrest, but you still would have to do at least 5 days mandatory. Have you had an OVI before?
I relapsed after 2 years, and
Okay.
the first thing I had is shaking.
All right. Now, are you?
Just got my license just got reinstated.
All right. Now, are you under the influence right now?
No.
Okay.
Right now it's last Monday, and it wasn't drug related.
Okay.
A jealous gap friend of mine broke out another fella's window. at
Okay.
my house. I got hit with the bat. I had to go to the hospital, get paperwork for it. I got out Thursday evening. So moving fast, getting up, raising, all that. This is what my equilibrium.
Okay.
I tried to explain that to the officer.
All right.
I can't do that test now, and they hadn't done it.
Okay. Miss Ivy from our probation department? Yeah.
Defense attorney has said that alcohol, cocaine is a real issue.
Okay.
And she does not drug.
All right. So we got to get that on the
I
record.
didn't want to. Oh, you want?
That, well, at least that you want drug court.
Okay. Okay. Thank you.
All right. So we're going to resolve your case today, right? And I'm going to hear from the prosecutor, but there are a couple of ways to handle it. Now, once I hear from the prosecutor, there may be a shift in how I handle the sentencing. Normally, you'd be looking at immediate jail time to resolve the OVI, but there may be something else that we're doing. Madam Prosecutor, as well as our...
Yes, on 3-7, Officers Batista and Sergeant Beasy saw a car stopped in the roadway with its hazard lights flashing. They initiated a traffic stop, and the Chevy rolled forward and pulled into a driveway. Sort of like today, when they encountered her, they said that she appeared confused and her movements were uncoordinated. She had an open can of Smirnoff alcohol sitting in the cup holder. She dropped a Crown Royal bag and it had a metal scrubbing can fell out. They administered the horizontal gaze nystagmus test and determined clues in both of those. They asked her had she been drinking. At first she denied it. Then she admitted to drinking what she had in the cup holder. She admitted to smoking marijuana. They attempted to do field sobriety, but she was having difficulty balancing and kept putting her foot down. They tried to, stop the test, but she was insisting on trying to do it anyway. So at that point, they decided to go ahead and arrest her. Then they started inventorying her vehicle, and they found what appeared to be crack and drug paraphernalia, which she stated was definitely crack.
All right. We need a day for probation. Ma'am, you wanted to say something?
Absolutely. There's a building sitting right here on Taylor and Terrence. My she's like a big woman. She stayed right in that corner building. I didn't have my phone. I literally told the officer, you can do a breathalyzer. Just crack it so I can get out the car, we gas it and quit. That's what I did.
Okay.
So I hadn't been drinking. However, earlier that day, I had just started.
Okay.
Didn't have it.
All right. And you said you had a relapse, so we're gonna work through that. So, madam,
For the record,
probation.
I will say I didn't see any priors on her
Of
driver's
OVI?
record.
Okay. Miss Ivory.
Yes, Your Honor, Patricia Ivory, East Queen Probation. Your Honor, I had an opportunity to speak with Ms. Wright. She has agreed, if the court agrees, for her to enter the drug court program. And so that's what we're requesting.
All right.
Drug court.
All right. So, Mr. Wright, you're gonna meet with Miss Ivory, who's right next to you, on next Wednesday, March 17th at 3 p.m. And we're gonna go ahead and work with the drug court program so we can see if we can get you back on the right track. All right. Any questions?
At this point, I'll take the guy I got from.
All right. And we're gonna do what we can to help you out. So you'll see Miss Ivory. Okay. You can step down there. All right. Martinez Waller. Okay. Mr. Waller, I have a few cases here. They look like they're all from the same day, but they have misdemeanors and a felony. The misdemeanor first one is 21 TRD 01151, no driver's license, reckless operation, and it looks like improper plates. Then there's 21 CRB 00240, having a drug or a controlled substance on you, as well as possession of criminal tools. Those are first degree misdemeanors, which means you could get up to a $1,000 fine and 6 months in jail. But then I have the felony charge, 21 CRA 00247, failing to comply with an officer's order, possession of drugs, obstruction of official business, and criminal tools. And let me read to you what those particularly mean. The possession of drugs, they have it charged as an F3, which means you're looking at 9 to 36 months in prison and a $10,000 fine, because they're saying that on March 6th in the city of East Cleveland, you did knowingly possess 8 suspected ecstasy pills exceeding the bulk amount. Then there's a charge of obstruction of official business, a felony of the 5th degree, stating that you did flee from officers on about March 6th by fleeing on foot from the scene after committing the felony. There's failure to comply with an officer's order, because they're saying that you were in a vehicle and failed to stop when officers gave you the signal in order to stop on March 6th, 2021. That's a felony of the 3rd degree, 9 to 36 months and a $10,000 fine. And possession of criminal tools, because they're saying that on or about March 6th, there was an iPhone, contraband, 8 pills of ecstasy, and baggies of marijuana, as well as a digital scale, all presumed to be used for criminal activity. So, felony charges can't stay in East Cleveland. You understand that? You spoke with the defense attorney. Let's start with that. Ms. Conwell, how are we proceeding on the felony charges?
Okay, with regard to felony charges, the plaintiff has right.
So that means the felonies will be sent to the county. You're still not guilty. And we're going to set a date for that, which will be Monday, 12th floor of the Justice Center at 9:45. I'll give you a reminder. Now, I need to know from the prosecutor and or the defense attorney on these misdemeanors. Are they going down also? Are they all related? Hold on one second. Yeah, the criminal tools is the possession of the digital scale, and the contraband is the marijuana on the front passenger board floor. So it looks like they may be similar or duplicate charges. So I'll just make sure they're all together at the county. Sir, you have a question.
Yeah, I was just wondering how it's being charged with the skill if it doesn't work.
Okay. Well, let me do this. So first of all, couple things. How old are you?
I'm
23. All right. So first thing to keep in mind, your attorney normally doesn't want you to speak, which is why I'm gonna cut it off here. Everything is just a charge, but everything has to be proven.
Right.
So right now you maintain not guilty on everything. And at some point, the prosecutor downtown has to prove everything. They have to prove that you had a scale, that it was going to be used for, or that they believe it was used as criminal tools. So all of that.
Yeah.
So right now, just maintain not guilty,
Okay,
and we'll get the case sent to the
I have
county.
one question.
Mhm.
Well, I work at Amazon, and they took my phone for evidence, and I need my phone for my money is on there because I don't know my cash app and all that information. Like my tax is supposed to be going there, and my paycheck.
So what happens with that as of right now? Because you are right now accused of trafficking in drugs, right? And you're not guilty of it. Until the detectives decide, or your lawyer who you'll have downtown, that your phone had nothing to do with that, right now they are alleging that your phone was part of your business. Now, I'm just trying to give you an understanding of why everything is the way it is. So right now, the detectives can say, hold on, Judge, we need that because we're still building our case, against Mr. Waller. He's already saying that the scale is not his, the drug, all that stuff is not, hold on, don't say a word. Everything is already not guilty by reason of law. So they're still saying that that's part of your business. Now, if the detectives at some point decide, you know what, we don't need his phone, they can release it immediately. Or you can motion for the judge downtown to release it. But right now, because they're saying that that was part of the crime, I can't release it. Detective, is there any position at the city right now to release his phone? I mean, I don't want to put you on the spot, but you can if you wanted to.
That cell phone is going to be turned into the Narcotics Intelligence Center, and it's going to be downloaded.
All right. So basically, they're going to make sure or see if it's part of what they're alleging you were doing. So at this point, you can't get that phone back, but you can still renew that motion to the judge downtown. Right now, my job is to move the case from this court where it's not properly held because it's a misdemeanor court to the felony court. All right. Detective, on the bond for Mr. Waller.
We request, Your Honor, that we keep it at $50,000. He also led police on a long chase through several cities in Cleveland, East Cleveland, Euclid, and a couple other cities.
All right. So, Mr. Waller, what happens with the bond is that the bond that's set here is a bond that takes you from here to the county. Once you get to the county and everybody else charged with a felony, that judge can reduce the bond or they can increase it if they wanted to. And what they normally take into account is COVID-19 and the overcrowding of the jail. So it's a good chance the bond could be reduced or it could be increased. So if you're not able to make your bond before you leave here, it may be reduced when you get to the county. All right. Any questions about bond? Okay. Is there any bond that you can't afford? Okay.
Dude, I never.
Okay.
What's the personal bond?
Yeah, a personal bond is where you don't have to pay any money, but that doesn't normally happen with felony charges because I have an obligation to make sure the case gets sent to the county. That judge, so for instance, your court date is Monday. So if you're not able to make your bond by Monday, the judge downtown could actually give you a personal bond because that's going to be your judge through all of these charges. I'm just your judge right now. And as soon as you sit down, I'm not your judge anymore. So once it gets to the county, that judge, if you make the request for a personal bond, let the judge know that you're working. Let them know that you're not going to run, even though fleeing and eluding in a car doesn't speak well to somebody trusting that, that you're not going to run. That's you got to make good decisions, but that judge can lower your bond. All right.
I'm probably pay $1,000 to get out of here.
$1,000, we can't lower the bond to 10,000 mainly because of the fleeing and eluding. So I don't know if you know, and I'll say this and then I'll be done with it. For some reason, I don't know why, but that's been happening a lot with, young men and women today. I don't know why, but the running from police or taking them on a high-speed chase is happening a lot. It's not only dangerous to you, your health, but also the community. You can hit somebody, you can hit somebody walking across the street, run into somebody's car. So that's getting to be a very serious charge, which is why I can't give you a low bond on that. At some point, you and me, we got to get this message out that that's an unsafe thing to do, and that the law is not going to, really condone that. So you got to make good decisions. If you get, yeah, it's not that, but when you get in a car and you go even 5 miles over the speed limit, you may not be a repeat felon, but you can kill somebody. That has nothing to do with whatever they claim you had something to do with. So part of this whole thing is when you get caught with this situation, I'm just speaking to you man to man. If you got something on you because you're not guilty right now, it's like, okay, I made a decision as a young man. I took a risk. I got caught, and I'm gonna take a responsibility. But when you drive in that car and put the whole community that's driving at risk, that's a whole different game. It goes up from there. But nevertheless, detective, I can move it to. He can't afford a $35,000 bond. If there's no objection, I can move it a little bit, give him a little bit of chance to get out of jail. I won't move it to a $10,000 because I can't do that. Is there an objection to $35,000?
Your Honor, I would still like to keep it at that because one vehicle was struck.
There was a vehicle
Yeah.
struck.
And like you said before, there were several lives in danger, and he was all over the place.
All right.
He also had a female in the vehicle.
Okay.
So it could have endangered her life also.
All right.
And he did drop her off halfway through the pursuit.
Okay. All right. So a lot going on that I don't know about. All right, sir. But again, not guilty on everything. Once you get downtown, they'll be able to address a little better for you. So
Will I be able to bond over today to the county to bond out?
Absolutely. If you don't post your bond, they're gonna get you down to the county probably today. Yeah. Okay. You can have a seat. William Bennett. Mr. Bennett is here on a charge of criminal trespass. Mr. Bennett, it's a first-degree misdemeanor where they're alleging that you delayed the performance of police by fleeing on foot from officers on or about March 8th. It's March 11th. You've been in jail for, 3 days? All right. You're going to enter a plea to a minor misdemeanor. It's being reduced to a no jail time offense and a maximum $150 fine. Is that your understanding? All right. Mr. Bennett, when's the last time you worked? Who do you live with? In a group home? All right. Why'd you run from police?
No, I didn't know I did. I was just standing there until you came at it. I just started running.
All right.
And then he cut me down. He said, "You all right?"
How old are you?
40, 50.
Oh. All right. Which one?
March 1st.
All right. So how old are you on March 1st?
48.
All right. So you can still run. Your legs still work, right? And that cost you jail time. So what I'm gonna do is accept your plea. I'm gonna release you from jail. I'm not gonna fine you any money because it's not about that. But you don't want to spend time in jail when you don't have to. All right. So I'll accept the case being resolved today. You don't owe me anything. You'll be released. All right. Take care. Court is adjourned until this afternoon. Well, I'd already signed the first one, so and it was a seatbelt.
New date on Mr. Mahaly.
Who is that?
Look here, let me just take this.
Who is Mr. Mahaly? Be back soon.
Mahaly.
Oh, this afternoon?
Here we go.
Which one?
I think you guys
The loud one.
Oh, that's set for tonight.
Yeah.
I mean today.
Yeah.
Two other
He was
trials.
here.
I don't know if they want that.
And we got Hassan.
Well, I didn't think he was set for trial.